Hi everybody, welcome back to the 10th of an hour with Griffin Bridgers. For today's episode, episode 79, I'm going to present the first of what's going to be a series over time of presentations where we dive into some classic IRA rulings. Because as you might have gathered from some of my previous discussions, there's a lot of issues surrounding the naming of trusts as beneficiaries of IRAs. And in today's presentation, we're going to dive deep into Private Letter Ruling 2016-33025, and we're going to look at a possibility of an intervening general power of appointment and how that might affect IRA planning. Now, as always, this presentation is not intended to substitute for legal or tax advice. So, I'm not going to dive back into the trust as IRA beneficiary rules in depth again because I've covered that in previous discussions, at least on a more than surface level. But a big issue with IRA planning is that a trust can be an IRA beneficiary and get a stretching of IRA distributions over the lifetime of a beneficiary, but only if, amongst other requirements, you can look through the trust to determine the beneficiary with the shortest life expectancy for purposes of calculating RMDs. Now, one way to cut off the consideration of beneficiaries is by structuring a trust as a conduit trust. What that means is that any distributions from the IRA to the trust itself cannot be accumulated within the trust and have to be passed through to one or more beneficiaries as if those beneficiaries were just direct beneficiaries of the IRA itself. And when you do that, if you have a conduit trust in place, you can disregard every possible downstream beneficiary. Those are known as remainder beneficiaries. Some may be vested remainder beneficiaries, some may have a contingent remainder, but if you don't have a conduit trust, you have to take into account every single one of those potential beneficiaries in determining one, the beneficiary with the shortest life expectancy, and two, whether there's even possibly an entity such as an estate as a beneficiary of the trust. In that case, you don't get a stretch. Since you have an entity in the mix, you have to use the 5-year payout rule. Now, as you can imagine, that's a deep rabbit hole to dive down, but what if there's a way you could avoid that rabbit hole and cut it off without using a conduit trust? Now, there's no hard and fast guidance on exactly how to do so, but there was an Easter egg hidden within this private letter ruling I mentioned. Because in this case, the IRS approved the use of a child's life expectancy, because the child was the key beneficiary of the trust, in a case where there was a testamentary trust named as an IRA beneficiary. Now, there was nothing really special about this trust. It resembled what you might see in a lot of trusts, in that you had a child who could receive all trust income, but there were no conduit provisions. So regardless, the trust had certified in the private letter ruling application that it had been administered as a conduit trust up to the time of the ruling request. Now, the child and the child's issue also were entitled to receive principal for their health, education, maintenance, and support. And the trust was not one that lasted for the child's lifetime. At age 50, the child was to receive the balance of the trust assets. Then finally, if the child died before reaching age 50, the following would happen. One, if the child had issue at the time, the balance of that trust would go to the child's issue to be held in trust for their benefit until age 21. But if any issue died prior to age 21, the balance of their respective trust was paid to their estate. And then, if the child died at age 50 with no living issue, the trust would then go to siblings of the decedent. So it would go upstream then to older beneficiaries. Now, that would have been a concern pre-Secure Act, but post-Secure Act, it's not as big of a deal, and we'll look at why in a minute. But for the time being, there are two shortcomings in this ruling which many practitioners have cited. One being that the life expectancy of the siblings was not taken into account in determining the beneficiary with the shortest life expectancy, even though the siblings were contingent beneficiaries here. And two, the IRS also ignored the possibility of an issue's share going to the issue's estate if that issue had died prior to age 21. And in the worst case, what would have happened here is that the 5-year rule had applied if the IRS had taken into account an issue's estate as a contingent beneficiary, or maybe better, the IRS would have used a sibling's life expectancy in determining the IRA distributions. Now, post-Secure Act, since we have a mandatory 10-year payout for individual beneficiaries who are not eligible designated beneficiaries, this isn't as big of a deal. But one thing to think about is that the IRS didn't mention this, but the issue, by virtue of having their IRA payable to their estate, if they died prior to age 21, in essence had a general power of appointment over trust assets, including the IRA, if and when that trust was created. So the question here is, did that general power of appointment cut off consideration of the siblings as remainder beneficiaries to the issue, and even did it cut off consideration of the issue's estates? So in other words, does an IRS rank a general power of appointment over the possibility of an estate being a beneficiary when it's determining whether the 5-year rule applies? Now, post-Secure Act, one important point here too is that the issue after reaching the age of majority, which we could assume might have been 21 here, wouldn't have been able to stretch out IRA distributions anyway. So other than determining whether the 5-year rule applies, the Secure Act has rendered some of these questions moot. But one big question here, to repeat again, is since there was an intervening general power of appointment held by the issue, did that cut off consideration of all contingent remainder beneficiaries downstream of those issues? Now, it's a good Easter egg potentially that's hidden in this IRS ruling, but there's a lot of shortcomings. One, this isn't necessarily called out, but it is possibly a good speculative tool to look at when you're doing IRA planning, is could you build in a general power of appointment for a beneficiary downstream, and in doing so cut off consideration of contingent remainder beneficiaries in a trust that otherwise would not qualify as a conduit trust? Could be a good planning tool, but there's nothing out there condoning it, so try this at your own risk. And keep in mind, there are issues with giving a general power of appointment too down the road, obviously beyond estate inclusion, that could prevent allocation of GST exemption to the trust up front as well, depending on which beneficiary has the general power of appointment, if it's a current income beneficiary or just a contingent remainder beneficiary. And that's a discussion for another time, but for the time being, maybe keep this in your back pocket if you do a lot of IRA planning. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thank you for listening to this episode of The 10th of an Hour, and I look forward to seeing you in the next one.